Gentlemen, I'm very delighted to stand before you today. The topic of my presentation is litigation risk in emerging economies. I'm going to share with you some of the few cases we had in Africa and some part of Asia that defines the essence of litigation risk and why it should be so important to us as lawyers. The question is this: litigation risk is increasing with the rise in global commerce. Most transnational companies and multinational companies are expanding, all in the bid to have return on stakeholders' investment. But then the cost of litigation as well is increasing in equal proportion. How do you strike a balance? What you have gained working, producing in developing countries, you are paying through claims and frivolous litigation. It becomes an issue of concern to all. But how do we perceive litigation risk? How do we perceive litigation risk? Our perception to litigation risk will determine how we respond to it. It's been said that litigation risk itself is a check. It serves as a check and balances on organizations operating in developing countries. That without the risk of litigation, the companies would conduct their business without any recourse to law, without regards to the host community. So the fear of litigation itself serves as a check and balances on these organizations or companies operating in developing countries. As well, litigation risks serve as a tool for holding companies accountable for the social consequences of their actions. For instance, in my country, you have Nigeria is an oil-producing country. You have oil companies, exploration activities, the impact of these activities on the environment. The fear of litigation itself prone the activities of these companies to size, enables them to adopt best environmental practices in their operation. Without the fear of litigation, what would have happened to the coal mine workers in South Africa? I'll run quickly some of the cases against transnational companies in Africa. Now, the protracted nature of litigation, we've witnessed quite a number of litigation against multinational companies and transnational companies. In South Africa, you have between 1995 to 1998, a case that lasts 3 years, involving uranium. There was an issue of cancer that the company was sued in the UK, having cancer. There was an issue of uranium cancer that they claim that in the course of their working on the job, they had cancer and they had to sue the company for that reasons. Then you have equally a case involving mercury poisoning. Now, mercury poisoning of South African workers, that is predominant. We have a series of cases along that line. You have oil spill cases in Nigeria and a host of other places like that. I'll make the slide available. But the interesting thing about this thing is this: it's not in the volume of cases, but the lessons we learn from these cases, how it adjusts the way companies operate all around the world. There's a rise in litigation risk, and litigation risk will keep rising. 3 reasons I've identified for the rise in litigation risk are third-party funding, class action, forum shopping, and foreign direct liabilities. Third-party fundings. I'll give you an instance. The farmers in Nigeria, or the peasants, the fish farmers, the people who live in the rural communities near the oil production platform, they are poor. They can't afford the cost of litigation. So what they do is they get individuals who walk up to them and request that they fund and bankroll the cost of litigation. They donate a power of attorney. They appoint those individuals as attorney. They fund the litigation. They commence the suit against these companies. Now, it has become a business, and it's gradually become a business. In the UK, for instance, we have, yes, institutional third-party funding organizations and agencies. You have them in America, you have them in UK, but in Nigeria, it's becoming a business. It's becoming a big deal as well. What it means, the volume of litigation against multinational companies will keep increasing for this set of people to remain in business. Even in cases where you don't have to litigate, because they see it as an avenue to make claims against this company, they go forward and commence litigation. Third-party funding certainly increase the volume of litigation and expose companies more to litigation risk. You have class actions. Most of these people don't just commence litigation on their own. They don't have the capacity, they don't have the wherewithal. They come as a group of farmers, as we see in the case of the South African mine workers. The Zimbabwe, you have group of workers, group of people. In the case of Nigerian oil spill matters, you have members of a fishing community coming together to commence action against the oil-producing companies in Nigeria. So class action is becoming an avenue for ventilating claims against these oil companies. They have forum shopping and foreign direct liabilities. Now, most of this litigation against multinationals in Nigeria are not commenced in Nigeria. We have there are cases of actions, violations in Nigeria, and action is commenced in the UK because they feel you have better access to justice in the UK than in Nigeria. And we've seen instances where, a couple of cases where the UK court, the English court has assumed jurisdiction, have made pronouncements on some of these claims. Now, when it first came up, there was a case from Ecuador. The ambassador of Ecuador then made a challenge that for an event that occurred in Ecuador, that the Ecuador court should exercise jurisdiction over the matter, not the English court. In the case of South Africa, no. South Africa, they felt, well, it's a good and welcome development. If the English court is of the view that the mine workers will not have access to justice or legal representation, and that is made available in the UK, so be it. So with the advent of foreign direct liability, forum shopping, UK courts having judgments against transnational companies operating outside their immediate environment, there will continue to be rise in litigation risk. So the litigation risk is more encouraged and fuel is increasing by the current trend and the pronouncement of the English court. You have similar claims in the US. An action was instituted against Texaco, for instance, in the US. It kept increasing. They happen in Africa. But the forum for adjudication is in the US. They feel they have better compensation, better legal representation. So that encourage and fuel litigation. Now, the possible areas of litigation risk while operating in developing countries. If you have external counsel or foreign counsel representing your interest or your company or acting as local counsel for your transaction, you need an external counsel who is vast with local laws and regulation. There are quite a number of law firms in Nigeria that provides regulatory and compliance services. You call and they advise on what it is and what the position of the law is. If you're not abreast with the local laws and regulation, you run into litigation. So you must be up to speed and up to date in what you do regarding this legislation. Now, another area of possible litigation is government contracts. When you have transactions with government and there's a change of government. We've seen situations where contracts and agreements are being revisited. For one reason or the other, you have cancellation of agreement, you have government rescinding on what was initially agreed. That itself could spark up litigation, and it's an issue of concern. So how do you get the sovereign commitment? How do you get the government committed to what the agreement they have signed? So these are possible areas. Then you have the CSR, the corporate social responsibility, the non-binding obligations. Now, for the oil companies and multinationals operating in developing countries, it is important that you take this aspect of your operation very, very important, and you know the source of your problem, some of the sources of the litigation. Mismanaged CSR program could bring about litigation, and lack of CSR means the host community will be hostile, and the host government could be hostile to your company. Now, dealing with unethical officials, dealing with public officials, with the advent of the FCPA and the UK Bribery Act, you've seen there's a change in the compliance landscape. So when you're dealing or you have representatives dealing with foreign officials, you have to be mindful of the nature of transaction so you don't get caught in the act of bribery. Then you have labor unions, employers' relations. Yes, employee-employers contracts must be properly managed. Environmental right issues flowing from the operation of your company. You have to take this into consideration and ensure that you apply uniform standard. If you produce oil in America, you produce oil in Nigeria, the same safety standard that you apply in America should apply in Nigeria, should apply in Ghana, and that will reduce your risk exposure. Now, it's important that you identify risk. The possible areas, you must identify risk. You cannot mitigate or prevent risk if you don't know the possible areas that this risk will emanate from. So you must know which of your business activities may likely or most likely generate litigation risk. And this you take into consideration when developing your mitigation plan. Now, litigation risk mitigation. How do you mitigate litigation? Some of the strategies that I just quickly run through them. You must have an internalized litigation prevention mechanism. It is important that you build this as part and parcel of your business processes. If you don't do that, as in-house counsel, you have so much work at your disposal. You have so much headache coming from the business line. You must carry them along at all times. Let them be part of the litigation strategy. What is the litigation objective? What is the litigation appetite of your company? Then you have a means of identifying and providing corrective measures at all times. Then you train your employees, you train the business line, let them know key and sensitive areas. Yes, you must be abreast with legal issues in the industry, the evolving trend. This will help you to stay up to mitigate litigation risk. And as well, it's important you have host community and government support through CSR. Like I said, if you're good to the government and you are good to the people, you have less stress, you have less issues to deal with, and if there are issues, they'll be willing to discuss with you and settle some of those issues amicably. You align litigation strategy to your business strategy. It must work together. Both must work together. It's important. You know what the business strategy is. You save costs, avoid reputational damage to the organization. So there must be a coherence among these two. Then in all of your agreements, you ensure that you have ADR, alternative dispute resolution clauses in all of your agreements. And so that I want to say as well that you have EPC clauses to avoid corruption. The EPC is anti-bribery and corruption clauses. You have that in your agreement. Stay out of corruption, any illicit act. Then ADR clauses too will help in great measures because that is the first point if there's any dispute. We encourage that you have a conflict resolution team, grievance mechanism where the customers, clients, host community, they have issues with the company. They have a first line reporting where they can go to and state their complaints You invite them for a meeting, see how you can resolve these matters amicably before they get out of hand. The whole essence of litigation risk mitigation is to prevent litigation. So some will be disposed, some people will be disposed to settle out of court. Some may not be favorably disposed to settle out of court. But whatever decision you are taking in this regard, you understand that a part to litigation is a part of war. So it's inevitable. Dispute is inevitable. But how you manage the dispute is the most important thing. Some you win, some you lose. But then, in war times, what do you expect? There are battles here and there. Some of the litigation battles can be resolved through alternative dispute resolution. And the number of battles you win will determine who wins the war. So as you incorporate this as part of your working process and practice, I think it will make your legal department less of a cost center, but a value addition to your establishment. Thank you very much.